So this is a meeting of the licensing subcommittee of the California Paraprofessional Program Working Group. I'll start by taking roll. Brynildson.
Present.
Hamilton.
Present.
7 to 10 days.
Judge Harper.
Present.
And Torres Ambriz. And Claudia had indicated that they weren't sure if they would be able to participate in today's meeting, so maybe Claudia will be able to join us shortly. I'm going to see if there are any members of the public, any attendees. We have one attendee so far. If you'd like to make public comment, please raise your hand in the Zoom meeting. And otherwise, it looks like we can get started. So I wanted to start by referencing, oh, there's Claudia. Great. So Claudia, just for the roll, just call your name for the roll.
Thank you. Yes, I am here. I'm
Okay.
offside, but I am here. I can see you all.
Okay, great. Thank you.
Thank you.
So I want to start by referencing the email that I forwarded from Judge Yu, and unfortunately misspelled her name in the subject line, where she brought the concerns that were raised at the board meeting, and perhaps Justice Petru, you can speak to that as well. There was a concern about the.
I mean, I can, but I think Judge Yu laid it out very clearly and accurately in her message. I do think it's important that everyone read it if they haven't already. But as I think, and I apologize at this point because I can't remember to whom I said what, so I can't recall. Leah, have we already had the conversation with this group about? We have about our conversation with the
about
state
the
bar.
board. Mm-hmm.
Right.
And
So,
yeah.
No, go ahead.
No, I think that resulted in some of the at the last meeting of this group. We did begin to start making some changes in response to that board feedback. And now we've got this additional request from Judge Yu, which is really specifically related to the pilot, which I think, Justice Petru, you might want to talk about it in the context of the pilot. Yeah.
Well, it's in the context of the pilot only by virtue of the fact that we shouldn't have two totally separate programs. In other words, we shouldn't have a set of criteria for the pilot and then a set of criteria for like the real long program, because A, that's a huge disincentive. B, it doesn't allow us to collect the data that we would want to have through the initial phases of the program to see what needs to be tweaked. And C, we question whether, it really is necessary anyway. I'd also encourage everyone, if you have not already, to read. Linda forwarded, I believe, to everyone the correspondence from the individual at Hastings that was sent a couple of maybe 10 days ago or so. Is that correct, Linda?
Yes.
Okay. And that also, raised a point that we have discussed before, but that I think is very important to keep in mind, which is we're not comparing what does someone get from a paraprofessional necessarily to a fully licensed attorney, although one can argue that under certain circumstances it might be better. But we're comparing it to what do people currently have access to, which is nothing, potentially an LDA, potentially a paralegal under the supervision of an attorney, but you really have to hire the attorney. And potentially, unfortunately, being defrauded and taken advantage of under various circumstances. So I thought that the correspondence from Hastings laid out those issues pretty nicely, and also laid out the issue that really it seems that, and I have to say I share in this view, that the vast majority of work that is needed is not necessarily done better by someone who has a JD and has passed the bar exam. There are certainly many kinds of cases where you need that level of education and demonstrated facility as is done via the bar exam. I mean, I've certainly been personally involved with many of those cases myself as an attorney and as a judge, but for the bread and butter of what the majority of people are going to court for most of the time, it's not required. And I thought that letter from Hastings also did a good job of talking about that. So kind of holding those things, that we're not talking about giving people a lesser service. We're talking about, what is needed, what do people need, and what kind of training do people need in order to provide those services in an appropriate and adequate manner at a reasonable cost, hopefully. Keeping all of that in mind, while keeping in mind that we don't want to have separate criteria for a pilot program versus a long-term program. What we wound up talking about in the pilot subcommittee meeting was, we think that all of the issues that you've identified and all the things you've identified are really important and really good. And so the question is, how do they get satisfied? Is there a way to satisfy these requirements? For example, if someone, we talked about this a little bit before, if someone took a course 2 years ago that is the same as the course that we're requiring, do we really need them to take it again or do more testing? Just all the things that Judge Yu laid out in her memo. So I had my head somewhere completely else before we started this meeting, so I apologize for any rambling or incoherence. Leah, is there anything you wanted to add? And you're muted.
No, don't think so.
So I thought this that what we could do, I'm going to share. I've created a chart that will allow us to very specifically discuss possible alternatives to the requirements that would still ensure that the competence that we need for the program. And I think in terms of looking at the educational requirements, I sent around, I apologize that I didn't send till yesterday and for one of them until this morning, a lot of detail on the course descriptions that were provided. I contacted McGeorge and they sent course descriptions. The request was made to the law schools, and this where we got a lot of the information from the registered and accredited law schools came from there's a group that someone in our admissions office who works with the law school sent out a survey, and we explained to them, these are the education requirements that we're looking at, and you can see they're on the left side of this first table. And are there courses that you're teaching at your school that mirror these requirements? And if so, please send us information about those courses. And so what I sent out was what we got in response to those. And as we look at each one of these requirements and look at alternatives, I can bring up and turn to the specific requirements in some of these course descriptions to see if we think that they would meet what we're looking for in the program. So the first one that this group is working with right now is ethics and professional responsibility, and we also included practice management. And so what I have in these options and alternatives is whether we would allow people to either test out of this requirement for the program if they've met the eligibility requirements, or if there's a course at the school that if they've completed that course, that would be equivalent and they wouldn't need to repeat it as part of the program. That's what I have in mind. Does that seem like a rational way of framing the discussion?
Yes.
Okay, so for this first one, the ethics and professional responsibility and practice management, do you want me to bring up the document that I sent out so that we can perhaps peruse some of those requirements in the classes?
Sure.
Okay.
And I'm going to suggest, and maybe this is not the right time for it, but we may want to consider splitting out practice management, because I'm pretty positive that's not being taught in law school. Maybe I'm wrong, but it is really different from ethics and professional responsibility.
Okay.
Can we define that term again of what we're thinking of as practice management?
Well, I'm thinking of it that it includes things like how to handle client funds, how to manage your calendar, how to basic office management, kind of running a business. Some of the issues that come up, we see it a lot on the attorney discipline side, especially when people transition from firm or government employment into being a solo practitioner, like just not knowing how to run a business.
So, yeah, I mean, I teach a law office management class, and we do talk about ethics. We talk about the difference between professional responsibility violation versus malpractice. And
Okay,
so that,
so maybe it should stay together.
yeah,
And I'm sorry, Julie, to just jump in for just 1 second. I just was curious because, and I think, part of this happened before I joined the group. And obviously I think law practice management would be a great idea for everyone to take. But again, it's one of these areas where we don't make attorneys do this. Like, attorneys can open up their own solo practice at any time without taking any law practice management courses. So I'm just pushing back a little bit on why we're requiring this, although obviously if I were opening my own practice, I'd certainly want to have it.
well, and I think the LDAs, they're not required to take that either, and they open their own shops, even though it's not for, the same kind of work, but it's similar. And I think that is something that is cultivated on one's own time. But at least I can say that in my teaching, paralegals are exposed to those types of concerns.
And
You know that paralegals are the ones that are not opening their own offices.
Correct. And yet we in law office management go over some of what is being discussed.
Julie, is that a required course?
Yes.
And one of the things we might consider is the feedback we're getting from these schools is if we include these options, that if they've completed the course at the school, that they won't have to repeat it. The schools are interested in then developing curricula and courses based on what the requirements are for the program.
I wanted to respond to you on this comment. So there are two reasons why I think that we could go beyond what we require of attorneys. Is one, we want the program to succeed. And we would be improving the chances of the program succeeding if the paraprofessionals got the practice management. I'm not committed to saying it has to be in there. I'm just
Yeah.
The second issue for me is just because lawyers aren't required to do it now doesn't mean we can't try and raise the bar. Because if now paraprofessionals are required to do it, doesn't it make it easier to argue that attorneys should include that too?
Well, I don't think attorneys are ever going to, I could be wrong. I'll be surprised if that's ever a requirement for counsel because, so many attorneys walk out into the profession and are not solo practitioners or not in, I don't know what the percentage is, but there's a very significant percentage that go into some kind of a public service job or, an established practice or all the rest of it. Like, do I think it's a good idea? Yeah, I doubt attorneys are going to ever need it. I don't know. I'm just pushing back on why are we doing this?
Well, can't we, for whatever minimal amount we want or see as the threshold knowledge that should be attained prior to opening up your own shop or doing this work? Maybe I'm in favor of the option of being able to test out of these things.
Sure.
And to include it into the professional responsibility exam. And if they can test out of that professional responsibility exam, those are the kind of things that I'm all for.
And is our thought that the vast majority of these folks are likely to be, for lack of a better term, solo practitioners?
I don't know. I think we're going to find that, Stevens had the idea that perhaps you're going to find attorneys who will use them in their offices to do some of the work that they currently do or some of the simple appearances. I don't know, but I'm not a family law practitioner.
Sure.
We asked a question of Judge Rubin and I recently had a conversation with a LLT from Washington, and she just said like about half of them are working in law firms with lawyers, and then the rest of them work either independently or together in partnerships. So I think it is a mix.
So is there general agreement that for professional responsibility that we would want to allow a test out option?
Yeah.
Is there consensus on that?
Yeah, I think we should. We should allow test out. If it was to become a class though, is there any stipulation yet as to how many credits or units would be required for that specific thing?
Yes,
I'm
and
just
it,
thinking about in terms of money.
right. So for all of them, except for the trauma-informed representation, there are 3-unit courses. And that's why I didn't put that in this table that I developed,
Yeah.
but they're all 3 units.
Stephen, did you have your hand up?
I did. Make sure I'm muted. Okay, I'll lower my hand. I was rethinking the testing out issue. If they have got a course that satisfies our criteria, then I think they can bypass the course requirement. Ultimately, they're going to be taking an examination that's going to include the questions on this issue. I'm thinking we would eliminate a separate, we're going to have to, if we're going to let people test out, we're going to have to create another separate test from the admissions or the equivalent of the bar exam, right? Versus just have those questions on the paraprofessional exam. If they've taken the courses, they don't need to take them. So we don't use the testing out vernacular. If they haven't taken the courses, they take them. And either way, they're going to get tested on those issues when they take the paraprofessional exam.
So I'm a little confused. I guess when I said test it out, I was thinking they could take that portion of the exam to practice. And if they can succeed at that, that to me was testing out. Then I think if that's different, then I don't know. I guess I thought that portion of the exam is what we'd be giving them.
I'm concerned that we're creating an extra layer of work to accomplish that when if they're testing out, are we going to allow people to test out if they haven't taken the coursework that would be covered by the program?
Well, you would have to have that professional experience instead of the academic coursework, right? I mean, I know for me anyway, at the universities when I've worked with test outs, we only do test outs if at least there's some professional experience backing up the experience, the information acquisition, I mean.
No, I didn't envision what Stephen was saying was that if they've taken the course, you get the course requirement done, then ultimately the paraprofessional test is going to decide whether you're qualified or not.
Yeah.
Correct.
So I think there's a little bit maybe of I don't know about a disconnect, but I think in the Judge You email, there's a contemplation that everybody would not have to take the test. So look, if you put your chart back up, Linda, it would be, let's say you're just gonna go let's say you go this route. You come in, you do the entire paraprofessional program, the educational credits and the 1,000 hours. Then under that scenario, I don't think the Judge You email contemplates a test, or you don't do all of the education credits, you don't do any of it. You just take the test. And
that's what I understood.
The test would substitute for education, not experience. So let me set aside the experience. But that it's an environment, it's a different paradigm where everybody wouldn't be taking the test. So in that way, it's not like a bar exam. But Justice Petru, you've been party to those conversations. Do you think I'm getting that wrong, or?
No, I think you're getting that right.
So can you state that again? Because I'm looking at Judge Yu's email. So you are saying that it would be a test that would then eliminate them taking the class only. It's not a test like the bar exam that they're going to take at the end.
Well, they wouldn't take a bar exam at that.
Okay.
I'm trying to, so for example, I feel like I'm going to be able to ace this test. I have not necessarily taken all these classes in law school, but I have a ton of confidence. I think I want to go the path of just taking this exam. So I take the exam, I pass it, and then all I've got to do is get my 1,000 hours. Another scenario is I've gone to law school, I've taken all these courses, I'm going to apply to opt out of the credit requirements because I've already taken all the courses. The state bar says, yes, you opt out. You don't have to take the test because you've passed all these courses in law school.
And as part of that,
you have to get your 1,000 hours.
Yeah, and as part of the having taken the courses in law school, we're gonna have to put in some time limit. It can't be that someone took a course 30 years ago.
Okay, well, I think that's different than maybe Stephen and I had talked about in the past. Is that what you contemplated, Stephen?
No, I expected regardless that you were going to have to pass an exam to become a paraprofessional.
That's what our initial conversation. So I think that's why Stephen and I are somewhat confused.
And under what Leah's saying, then who would take a test then?
Somebody that didn't have all the coursework, but felt they could pass a test. Right? If you didn't have it all, if you applied to get it, what maybe you said, I'd like to apply to get all these credits counted, but State Bar said no. I'm assuming a world where somebody at the State Bar is going to be looking at it.
And for example, just give an example, there could be a paralegal who's been working in one of these areas for the last 20 years and knows this stuff inside and out and may choose to self-study some of these things and, you know, could then sit down, take the exams, pass it. And honestly, we're kind of hoping that some people can do that so that we can actually start getting people out sooner rather than later.
So then the model you're envisioning, Justice, is that each one of these subject matters or requirements could have their own separate test. If you can successfully pass each one of these tests, and there is no examination at the end of the program, you just take the individual tests. And I guess what, would they be administered by the State Bar? Is that what we're thinking?
Leah?
I'm having a hard time getting to unmute. Yeah, the test would be administered by the State Bar.
So then if they pass those subject matter tests and they test out of everything, the only thing they need are the experiential hours.
Which is not a small, honestly, that is not a small thing.
Yeah.
Yeah, I mean, I guess I missed it in the sense that I never thought there was going to be the equivalent of a bar exam where you sat down, you know, for a day and did everything simultaneously.
Well, I guess it's because originally the subcommittee was just me and Stephen. we were off in our own little world for about 6 months. So,
And I think,
and look, you're still friends.
I actually am going to send a potential student to Julia, I think, in the foreseeable future. I think the reason we included the testing, because doesn't every other jurisdiction have a test requirement for their paraprofessionals?
I can't answer that. And I also can't answer whether they, you know, require the same level of experiential hours and all the rest of it.
Yeah, so that was kind of like 2020. My recollection is, I'll state it in the affirmative, my recollection is every single other program did have a testing requirement. And in terms of the experiential hours, we were right. I would say now that we're thinking about shading those down, we are in the middle of the pack.
Stephen, do you recall, sorry to interrupt. Do you recall, and I'm sorry, I just don't know off the top of my head. And as I noted, my brain's not full function today. Do you know whether, when you say there was testing in other jurisdictions, whether that was you have to sit down for the equivalent of a bar exam, or whether more like what I'm talking about, where you test for the individual things?
The impression we were given is an actual examination, nowhere near the length or size of the bar exam. So probably a 2 or 3 hour examination was the impression I got. I think I don't remember her name, but the LLT.
Sarah.
Well, it was amazing, from Washington. She might be someone we could reach out to find out what the testing requirement was there. I think Washington set an extreme for us that we don't want to model, because that is one of the factors that probably led to the program's demise.
Sarah is going to be at our February meeting. Sarah and a commissioner from Washington to talk about the in-court issue. But since they're going to be there, we can certainly talk to them. Linda, if you have some time while we're talking, because I do know you did a lot of work to see about other states' requirements, and you have
I think I have it in front of me.
Them. Okay.
I'm kind of doing this on the fly.
I
too.
think I'm looking at October 2, 2020, and it says that Arizona has the limited license legal practitioner exam. And then it says that Utah has a professional ethics exam and an LPP exam for each practice area. And let's see.
Yeah, and I have this too. The paralegal, Washington has the paralegal core competency exam, practice area exam, and a professional responsibility exam.
And Ontario has a paralegal licensing exam. So they all have a licensing exam. But if we want to call ours the licensing exam for the subject matters, then that's that. I mean, I guess the question is, do you want to administer a test out? And then I guess what we're saying, if they don't test out, they have to take the class and then
pass it.
and then pass it again. So what we're saying is to successfully complete your studies is not going to be a test administered by your instructor. It's going to be, you're going to get through this whole process, and to sufficiently complete the subject matter, you've got to now go take the test with the bar.
Either way, either you can take all these courses if they exist. So here's the reason why I am a fan of doing individual tests rather than saying, here's the one global test. I can very well see a scenario where someone has taken a number of these courses, for example, as part of a paralegal program, or perhaps they have a JD. So I can see a scenario where they have taken some of these courses, but not all of them. And I personally would like to afford that person the opportunity to only get tested in the subject matters where they did not have the opportunity to take and successfully pass a course.
But we also discussed the fact that there may be someone who's coming in who's not going to do one of the more rigorous subject matters like family law, and may just want to do expungements and some other sort of administrative things. Had we concluded that they would have to take all of this as well if they were only going to be a paraprofessional in one of those very limited areas?
I'm very supportive of endorsement specific education requirements and endorsement specific testing. So there will be, instead of a broad global paraprofessional test, I'm in agreement with Justice Petru, have it subject matter specific so that you can pass and achieve that endorsement. And again, the education should be key to that too, because the person that's only interested in doing collateral criminal would need far less education and far less testing than this person that's going to do family law and the 57 tasks that we've come up with on the family law subcommittee.
Right.
Well, and then there's certain things, for example, like ethics. Everyone needs ethics, right? You know, so there are going to be some things where it's across the board, but you raise a good question. And I don't know what the answer is of, you know, whether there's been the drill down for the different, you know, kind of subject matter expertise, you know, what's required off this list, but also because it's pretty clear that it's not going to be the same exact list, depending on whether you want to do family, unlawful detainer, collateral criminal, debt collection. To me, having it be a cookbook, essentially, where you can like pick these different things, gives us more flexibility. Rather than saying, here's the test for being a paraprofessional, it's here are the requirements for these different kinds of paraprofessionals, and you know, you can deal with them individually.
Well, so I guess what we're saying then is what we originally as labeling courses that were going to be required courses, we may go ahead then and take some of those required courses out. And so those doing collateral criminal and unlawful detainer may not have to go through and take all of these courses. Or are we saying that they're still going to have to take pretrial discovery and evidence, court procedure, and court advocacy?
No, we should hear from each subject matter group as to what they're going to require. Remember, a lot of our discussion in this subcommittee was influenced because of my work with the family law subgroup, right?
Yeah.
because I knew what was going to be included.
Of
And I could
course.
be more specific. So with regards to that, no. So again, what I'm thinking, there's going to be the collateral criminal column, there's going to be the housing column, and there's going to be the family column. It'll have education and testing requirements that are specific to that endorsement. And so you don't have to take everything, but then maybe overreaching, there's going to be the professional responsibility that's going to be required for all three, whether we're going to require the trauma-informed education for all three or just for family law hasn't been resolved. Does that make sense?
Yes.
I'm expressing myself clear.
It does. I just think we also want to think about portability of your license. And so I think in a way, maybe we're making it easier for people because they say, oh, I only want to do this, but you only want to do this right now. And then 2 years later, you want to do something else. We do want to make sure we're not creating such unique pathways for licensure that it becomes difficult to expand a practice. So that would be my only caution. But I think irrespective of that issue, is sort of that policy question of, are you going to be able to opt out of a test? Let's assume it's modular tests. So there's a test on ethics, a test on pretrial discovery. Each one of these has its own exam. And together they comprise a licensing exam, if you want to think of it that way, but they're modular exams. So do we want to create a scenario where if you've taken the course and passed it in a relatively recent time frame, you don't have to take the test?
Yes, I really think you should. Yes, as
Okay,
a consumer.
I see Stephen grimacing.
I want the test.
I mean,
Well, they're going to still have to take, aren't they still going to have to take the practice area test and then the professional responsibility test?
Then maybe I misunderstood Leah. If they are required, I want everyone who wants the family law endorsement to pass the family law endorsement test, regardless of what your background is, your experience is, what classes you took. Is your suggestion, Leah, that someone can opt out of the testing requirement?
I don't know if it's my suggestion. I just think that is the question on the table, and there's all of these different considerations that are at play, right? Including creating reasonable and timely pathways for people to enter into the profession. But one option could be you can test out of these, whatever these requirements are. These are the standard or general educational requirements. You could opt out of testing for all of these, but still have to test on the subject matter at hand. So you could say, okay, I've taken classes in ethics, discovery, procedure, advocacy. Nobody's going to have taken trauma-informed representation unless they went to UCLA Law School. But and then they can say, I've already taken that class too. So then the only test you would have to take would be your housing test or your family law test. You could create kind of a hybrid model where there is a testing requirement for some component, irrespective of the coursework you've taken.
Okay, that ultimately, if you want, I think we're saying the same thing. If somebody wants the family law endorsement, they have to pass the family law test. If somebody wants the housing endorsement, they have to pass the housing test. Same thing for collateral criminal. And I'm speaking to the ones that we think are going to be in the pilot program. And then, is that accurate, Leah?
Well, that's an option.
Okay.
Okay.
Another option would be no test. Go ahead.
Which is which would be very controversial. That's a debate that's been happening in the context of the pandemic around law school graduates and diploma privilege. And that has been very controversial. No lawyer is admitted to the practice of law in California without successfully completing the bar exam. So there would have to be, because otherwise you're delegating to these educational institutions the authority to decide who enters the profession, who doesn't.
Thank you.
Yeah,
Joe.
I think they've got to take an exam that's administered by the bar, or I don't think you're going to have people with confidence behind this process.
In my mind, I thought it was, so say I went to law school or paralegal school and I took an ethics class. I can test out of that requirement because I've taken that class. So you still are taking a test to just to test out of that one requirement. And if I didn't have that class, I need to take something that's going to get me ready for that test. So I can always test out of that, but I've got to have some foundation. But
Okay,
still, it's the test that's getting the checking that box that you don't have to.
I
do that.
still think I'm confused, Judge Harper. Are you saying that they can test out of taking the class, or what test are, when we
No,
say
they can
test out,
take a class and test out of that test, then makes you don't have to take that class again. So
okay,
I've
but
taken
then
it-
is that test again appearing on the exam that is?
No, once you've taken that test, you've met that requirement. And then if I'm going to do family law, then I'm going to take that family law test.
Okay, so what we're saying then is the state bar is going to administer for the subject matter areas that we are going to approve. And let's take family law because we want them to be able to pass the ethics, the pretrial discovery, the court procedure, court advocacy, trauma informed, and then a subject matter. So they're going to be taking all of these, and it's going to be the state bar that's going to put those exams up for them to take, and they have to pass all of them. For someone like collateral criminal, they have to for sure pass their practice area, for sure pass the professional responsibility exam that is given by the state bar, but we haven't decided how many of these other educational requirements we would give to collateral criminal. Is that what we're saying?
Oh, sorry, Julia.
Sorry.
Is that what you were saying, Judge Harper?
I guess so.
I wanted to let
here's the thing.
Claudia
I
jump
like
in.
look,
Oh, okay.
look, to me the educational requirements that are already there. I know Julia and Steve have been working on this for a long time. I think those should be the bare minimum requirements to because if you're saying 50% of the paraprofessionals are going out on their own, then they should have court advocacy. They should have these areas. They're not going to be relying on a law firm or another type of firm. So I thought those are going to be the bare minimum requirements. So this. Yeah, so then if you did already take that class, then you just have to take the test and then you're done. If you didn't take that class, then you need to take that class and then take the test.
Okay, when we're talking about the test, we're talking about the state bar administered examination,
Yeah.
not a local college deciding if you pass the course by testing.
That's my mind. Yeah.
That's the key that I needed clarity with. So
yeah, that's what the state bar administered tests.
Because I want this to still be regulated by the state bar, and I want to do exactly what Leah said. We don't, or whoever said it, we don't want particular colleges declaring that people are ready to go do this. I mean, that's how paralegals go now. They have to get a C or better in all of their classes, and then they're successful to get their certificate or an AA in legal studies, paralegal studies. So they don't have a test. So that's why I want to make sure that, so therefore our college has control of how many paralegals we're putting out every year. So I guess at this point, I feel better knowing that the state bar would be administering the test that we're talking that they would test out of.
Yeah.
So can we let Claudia jump in, Claudia, because you had a strong reaction to this, and then I think you got cut off. So I just wanted to make sure to hear what you had to say.
Thank you. Thank you. Just as a consumer, I do like the idea of being able to take the subject matter test kind of like a piecemeal situation. Right? Not necessarily all of them at the same time. I like the idea of being able to possibly pick up another endorsement later, like start with one subject that maybe interests me or, as a consumer, and then having that option to continue growing my practice, right? Like if I wanted to specialize in further things, that I should be able to do something like that. I also agree that the testing out should be handled by the state bar. It is important to have kind of a neutral entity that can oversee all of the different schools that may be, showing some of the contents. And I really thank you all, for being considerate of the time that it may take to complete this process, because as a consumer, that's how I'm making my choices of whether or not I consider an educational program. Is I need to know how long is it going to take for me to complete this program, imagining that all of the classes are available when I'm available. And then even beyond that, how long will it actually take for me to start working in the field? I think based on what we're talking about, it'd be about maybe the second or third year before I could actually start working, having completed the program, right? It'd be like the second or third year when I'm actually doing those 1,000 hours.
I don't think so. I think we got it down to the education and the experiential taking a year if you were doing your experiential at 40 hours a week. So
Yeah.
one semester
does about 1,000 hours a year, and that's full time.
Yeah,
Yeah.
I think we're talking about lowering the 1,000. I think that was already been suggested, and we don't know what the rest of the group is going to say. But I think the model that Julia and I were working always contemplated basically one semester of education at max, and then one semester of the experiential.
Well,
Okay.
and they can, you know,
And overlap.
depending on their work schedule, they could do it as 2 separate semesters. But my thing about the 1,000 hours, I think we have to keep it, because the lower amount we had before, you know, we had Amos, you know, demonstrating in communications to us that requirement was very low as compared to other programs throughout the country. So I right now am pretty comfortable with 1,000 hours, Stephen.
If we go back, just sticking with the education for right now, it sounds like there's some consensus among you around being able to, I'm going to call it, waive out of the coursework, a bit waive out of the educational credits based on having taken the class before. So that one would be a yes, waive out, right? And
Right.
then
With
you can, but you will still be required to take the course, the test. That's what I'm hearing from all of you.
Yes.
So-
A state bar administered test.
So you can't test out. That's not
No.
accurate. Like if you haven't taken the course, you can't just take the test without taking the course.
That's what
No.
I suggested. Yeah.
Okay, and now I'm confused again, folks.
If you've taken the course in the last 2 to 5 years, whatever our time parameter is, you could have done it previously and it would meet the requirements for an endorsement. But you're not going to let somebody who hasn't taken a course take an optional test to say, I haven't taken PRE, but I'm going to just take the test and pass it. And then that eliminates the educational requirement. What there's going to be though at the end.
For professional responsibility.
Yeah.
Pardon?
And you're saying that specific to professional responsibility?
I'm giving it as an example. For example, let's say somebody has taken a 4-unit family law course at Berkeley or Bolt, and we would give them credit for that against the, say, 6 units of family law credits we want for a paraprofessional, if that's where we end up. They'd still have to make up the other 2 units. But there's someone who doesn't have that experience, we're going to make them take the course is what I'm suggesting, and not let them test out of it because they've been doing it in a law office for 15 or 20 years.
But are they still going to have to take an exam on family law with the state bar then?
Yes, everybody has to take the endorsement exam.
Yeah.
So who is going to determine? I guess this is the other problematic thing, is because not everything is the same everywhere. Is, say, for example, what is my pretrial discovery and evidence class versus some other person's pretrial discovery and evidence class? How can you even say, okay, you don't have to take the class, just take the exam given by the state bar that will determine if you know enough of this? I mean, I've looked at transcripts before, and I mean, we won't even let non-ABA approved paralegal students use their non-ABA approved units against required classes in our program. So I mean, those things are examined in that way because they are considered a lower standard than the course taught by an ABA approved paralegal program. So they then have to retake that course.
There's got to be somebody at the state bar that at least historically reviewed transcripts to make some kind of determination of the credits. Greg, do you know?
There is. Yes, there is.
Yeah.
It's in the Office of Admissions. We do it now for like foreign educated students.
Okay.
There's a way to do it. But I think I'm sorry because I'm still lacking clarity. Like Linda has, yes, you can test out of ethics with presumably without having taken a course. But I'm not thinking that's where you guys are.
Correct. I'm saying the testing out idea has morphed, and I'm saying it's no longer part of, it's not an option. They either took the class or they didn't, and the class they took meets the office admissions criteria, or that somebody in Office of Admissions reviews it, make sure it's applicable. They're only taking the course if they didn't take it, a course that's accepted in paralegal or law school.
So everybody has to take every module of the exam, right?
No.
But you can get out of all of the educational credit requirements.
Yeah.
Can I just
No, yes on the second, no on the first. I'm saying everybody who wants a family law endorsement has to take the family law exam. Everybody who wants a collateral criminal has to take the collateral criminal exam. Those will be much different exams.
And on top of it, take the paraprofessional exam, which is going to include testing on the areas listed here, which include professional responsibility. So there's going to be a professional responsibility test and the other educational requirement test administered by the state bar. The other requirements, if the state bar admissions office accepts your coursework to opt out, not test out, but opt out of taking the course, then you only have to take the courses that the state bar says you have to take.
Okay, but do you have to take the corresponding exam for those courses?
There's not going to be an exam specific course. There's going to be endorsement specific exams.
Yeah.
What I'm suggesting, I keep saying it so authoritatively, and I apologize, but what I'm saying is a family law paraprofessional only has to pass the family law paraprofessional exam other than the professional responsibility, which is a separate requirement like it is for attorneys.
So there's two exams. There's going to be one exam for each practice area and then a professional responsibility exam that everybody's going to have to take.
So there's no exam for pretrial discovery, court procedure, court advocacy, or trauma-informed representation. Those are not addressed by examination. Those, no exam will cover it. Go ahead and jump in, Greg.
Yeah, good. Let's hear from Greg.
I just want to share what Arizona is doing because it may be helpful for us with this, because I hadn't imagined that the state bar would be administering a professional responsibility exam, a court procedure exam, and then substantive exam. It seems a little bit too piecemeal. So Arizona has two tests. One test is on legal terminology, client communications, data gathering, document preparation, ethical code of conduct. And then they have another exam, which I think Stephen's referring to, which is like the substantive law exam for that endorsement. So the portability comes in, I think, in that you take that test, that first test, which tests all these general topics that may be common across all different substantive areas that you may want to practice in. And then you have a substantive area exam as well.
Yes.
So then we're back to where you don't test out. You can get your courses waived because you already met those requirements. Then you're going to take the one test, which would cover all that area. And then you take your specific course area, practice area test.
Right. So I think you break the bottleneck by, hopefully, if you've completed a JD and you decide this is the career choice you want to make, you can waive out of a lot of the educational requirements, which gets you faster to the process of being approved to sit for the exam.
Yeah. Okay.
Correct. And I think that's what's been confusing. Linda, can you edit and say not test out, say waive out or something like that? Because this test out is what I think has become the problem.
So,
Proficiency waiver, something like that.
so I'm trying to understand, so in terms of this first column, it's not really relevant because the
No.
issue is that they don't have to repeat the course.
Yes.
If they've taken it, they don't need to take it once they're admitted to the program if they took it as part of their education.
Well, the state bar is going to decide that. Did their academic coursework meet this outcome? Did their coursework teach them enough pretrial discovery and evidence to where we don't want to require them to take that course? And that analysis is going to have to be done by the licensing. I think
Yeah.
it's because you can't get each college to make similar types of determinations. I think it would have to be determined by one body.
So that what Linda just wrote, that applies all the way down, correct? In every cell. Does it apply even in the practice area courses? So if I took family law in law school, then I don't need to take the 6 credits contemplated of family law in the paraprofessional program. Not talking about a test right now, just waiving out of educational credits.
Right.
Does that comment apply?
Well, is a family law course 3 or 4 units at a law school? Does anybody know?
I think they're all 3 units.
Are they? Okay.
And I think if you can waive out those other ones, you should be able to waive out. If I took the course, then.
Yeah.
Okay, so Linda, use the language waive out, not test required. Thank you.
Did you know?
So in theory, so I just went to law school for 3 years. I took all these courses. I decided I don't want to sit for the state bar, but I want to become a paraprofessional. I apply. The state bar looks at my courses, says, yep, those all meet the requirements, so you don't have to take any of those courses. I then can take the test, the paraprofessional test, and the practice area test, and then I can become a paraprofessional at that point.
Well, what about, okay, well, eventually we're going to have to say, can you waive out of the experiential then too?
Yeah, no, I don't think you, yeah.
Well, we'll get there next. So the Greg model, and I think where Stephen was going, there's 2 exams. One is universal, regardless of your practice area for licensure, right? And that's like the professional responsibility test. It's like professional responsibility plus.
Yes.
Got a little bit of some other stuff in it. But it's not going to be covering pretrial discovery, court procedure, court advocacy, or trauma-informed representation. Those things are not addressed in an exam.
No, they are. They are part of that exam.
Because is that because we're confident that that's going to be a requirement for all the different?
Well, if it ends up not being, then we'll have to go back and adjust that. But I think right now we should go with the idea, because I think you said, Judge Harper, that you envisioned that for anybody, they were going to have to be proficient in all of these areas if they were going to be a paraprofessional.
I would think so. That was my thought, yeah.
Yeah, I mean, I think we made the one paraprofessional test, and to include professional responsibility and other educational requirements, which are listed above. And then the practice area is so I say, yeah, there's 2 tests, one for all of the required education and one for the practice area.
Okay. And so then if there's a determination that all of those general requirements, if they're not consistent for each of the practice areas, then we would winnow down that portion of the test so that it only covers those things that truly apply to all practice areas.
That's why I'm thinking, instead of
That makes sense.
having the 2 tests, make it endorsement specific. And I know that means there will be some duplicate between family law and housing, because you're going to have the pretrial discovery and the court procedure in there. The collateral criminal, if we're going to roll this out in the pilot program, it's going to require much less Like, I don't, there's not going to be pretrial discovery and evidence skills required to do the collateral criminal, right?
Well,
I think there are actually.
can we
potentially.
wait to alter the requirements? Let's just stick with the most comprehensive so that we are, because I just feel like we keep wanting to jump ahead or jump back. Let's just talk about family law, Steve, because that's the first one you were talking about. And I'd like to repeat what Judge Harper said. He said, for right now, let's just contemplate that for every paraprofessional, this is what they're going to have to do. And then when we get to the substantive law or the endorsements, and those committees tell us what they would like to reconsider, let's deal with that then. Let's not do that in a vacuum, because I'm not a part of any of those subcommittees, just general civil. So I think we should wait for those groups of people before we start shaving it down.
Fair enough. I know the trauma-informed representation is a big issue with the family law subcommittee. Do we think it's needed, and should that be part of the general requirements for all paraprofessionals?
Yes.
I think that's what they're recommending. Yeah.
Just asking the question. I don't oppose that. I just wanted to ask the question.
So where we are with this is you can waive out of all of your educational requirement that there is not going to be an ability to forego a test. So waive out, but there'll be a test. And what this means in terms of wanting to create a quote unquote expedited path to licensure is that there will be a need to have that test ready, those tests ready fairly soon, right? Because the hope, for example, in a pilot is that there are going to be folks who can waive out of almost all of this and are ready to take the exam. And so obviously the exam will need to be available to them.
Yeah.
Yeah.
And we're going to want them to be able to take the exam as soon as they finish school, even if they don't have their experiential done, because why would you make them wait 6 months to take a test when it would be fresher in their minds? I think.
Yeah, no, I agree.
Okay, should we go on to experiential? Was it your idea that no one could, let me ask this question, and I probably should know this. What did you contemplate would be allowable in terms of clinical experience working as a paralegal, any of that counting towards those 1,000 hours at the time of application? So looking retrospectively to your hours, was there an idea that any of that could count towards the 1,000?
Yeah.
Absolutely.
Yeah. I mean, I think
That would be so helpful.
What was the time period, Julie, that we settled on? It was like
6
within the
months.
last 3 years, right?
Yeah. And I think it was, and I think what we're going to just require is that their attorney declaration supports whatever the tasks were that we want them to make sure was included in their experience or during their 1,000 hours would be set forth in a declaration by the attorney that attests to their having worked those hours. So by way of declaration, I mean, we would have to create what those tasks were in a format so they could easily download that and take it to work. But I think we were going to put it in the hands of the supervising attorney.
So in theory, then, right now, if we were to do that, then if I'm a paralegal that's been working, I've only been a paralegal for about a year, so I had all that coursework within the last 2 or 3 years, 4 years. I've worked all those hours, then you could right now apply to become a paraprofessional, take the testing, and become a licensed paraprofessional right away.
Well, I think that's probably not, they maybe or maybe not, but I think the state bar, when they see, for example, the law office, civil procedures and litigation, student learning outcomes, once the curriculum is more developed for court procedure, court advocacy, pretrial discovery and evidence, you're going to have to determine whether the student learning outcomes that they achieved And for example, our paralegal classes meet all of those. I
Okay.
think they may be higher than what is taught in paralegal school.
Okay.
But I do think, Judge Harper, you're right. I think there's going to be some people that are going to be able to fast track it, and we could have the first tested out paraprofessional within a short period of time. of the program.
Pretty quickly, yeah. So
Yeah.
it makes it almost, it could be ready to go, yeah.
Well, and I think perhaps that if you have a law school graduate who was, alert to all of this and is taking the courses in law school, I think they may be able to more easily pass this than the bar, and they may be the first ones out.
Sure.
But I don't know that paralegals are
Would, yeah.
going to
I was
be
just-
able to take a professional responsibility
I
exam.
was using that as an example, as in theory, though, we have people that could be ready to go right away.
Yeah.
Were you going to say something, Greg?
Yeah, I was just wondering, in terms of, we're talking about applicants for the program getting some experiential credit for work that perhaps they worked in a civil justice clinic when they were in law school recently. They would get some of those hours would go towards the 1,000 hour requirement. Is that what we're saying?
Well, I think it would depend on, I think we're using the work requirement to relate to the practice areas. So if they want to work in family law, I don't know that those experience hours are going to correlate.
Okay. But if they did correlate, I guess my question is, who's developing the criteria for determining whether or not certain experiences are going to be given credit? Is it at state bars, at the Office of Admissions, similar to what we were talking about in terms of waiving out of academic requirement?
I think once the subject matters determine what it is, all the I guess I'll call them student learning outcomes. Once each practice area or endorsement decides what skills they ultimately should have in the subject matter, then you could put those into an attorney declaration to say, over the last 1,000 hours in 6 months, they did this, 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 and have proficiency, boom. So I think we have to think about them as outcomes. What do we want the actual skill to be developed? What are we actually saying they should be able to do when it's over?
And I think it's that attorney certifying, whoever's going to certify their experientials is the one warranting that they did the work necessary during the experiential.
Okay.
It'd be no difference when I did the law office study program. I had to do my report every 6 months, and my supervising attorney had to attest to I did all those things. And if I remember correctly, it was under penalty of perjury too.
So that could be the same if they did a clinical program in the law school.
Yeah.
Right.
The professor could do that.
Right.
Yeah.
Yeah, that's an efficient way of dealing with it.
Because that may be the way collateral criminal gets their experiential hours, is working in some kind of clinic like that.
Mm-hmm. Okay.
Wow. We did it.
Can we
don't
go
think
back to the educational requirements as to how long we should allow those to count? So if you went to school 5 years ago, should those count, or what should be the time requirement?
That 5 years is stuck in my head as soon as
That's what's in my head too.
Well, I don't know. I think if they've taken this, because remember, we're dealing with paralegals where the new requirements for paralegals, I want to say, were passed, I want to say 2007. There was a grandfathering in clause. I don't know, we'd have to look under 6450, but an attorney could attest to you being a paralegal as long as that occurred by a specific date. So that was to take all of the paralegals that earned their right as a paralegal through apprenticeship working in a law firm to not be required to go to a paralegal school so that they could receive a certificate of training. So there is a grandfather period, and I think we don't want to lose those folks because they're never going to have taken all these paralegal courses. They would have been the ones allowed in as a result of a prior attorney declaration. And I want to say that's over 10 years ago.
So should we say if you're a licensed paralegal, then that would be in theory, a waiver of the educational portion, then they could test?
I'm not comfortable with the 5 years, Linda. I have to think about this some
Okay.
more. I think it's got to be, I mean, because realistically, if someone's been working as a paralegal for 20 years and took their education 20 years ago, why would we have a problem with that?
I was going to ask a question. If let's say I graduated from law school in '87 and I decided to pursue a career as a chef, and then in 2020, can I pop into the state bar and say, hey, I graduated from law school in '87 and I want to take my bar exam? Am I able to?
Yeah.
Okay.
Yeah. So I think that should be the same, because if they're not ready, they're not going to pass. That's
Sure.
So you're suggesting, Julia, no durational limit or no proximity requirement. It could be 20 years ago that you've taken the course.
yeah. I mean, I know we're required MCLE and that kind of thing, but I mean, here I've been a lawyer 30 years. I mean, other than that, no one else is requiring me to update my knowledge except that I have to in order to practice or to teach, right? So you do it
Yeah.
for your own survival.
And if I can jump in, when I was talking earlier about potentially having the time limitation, having had a course within X number of years, that was tied to the idea of not requiring testing. And so if you're recommending that there be testing for everything, then I don't think you need a time limitation on when the course was taken. Because they have to
ultimately
take a test.
Yeah, ultimately the test is going to be the final determining factor if you're ready or not.
Right.
Yeah, I'm okay with that.
Agreed.
Right.
Okay.
I didn't imagine we were going to finish this today. I'm just, I don't know what to do with myself. This is it, right, Linda?
Well, the only other thing was the idea of developing more incentives for attorneys to provide supervision.
Where's that list, Linda? Cloudy had some good ideas on that one.
So what we had so far was just the MCLE and also putting on the website that people should, that we would show that the attorneys who have provided supervision. If there were more that were discussed at the last meeting when I was on vacation, then okay. So
There was going to
that's a
be, you were going to be able to get your continuing education requirements up.
Exactly.
right.
Yes.
And I think that maybe there was we wanted to expand the number of hours of MCLE to increase that. I think, was there concern raised about that it wasn't enough of an incentive?
There was some back and forth. There was that issue. And then I had the issue of, do we want to let somebody other than the mandatory units satisfy all of their CLE requirements by doing the supervision? And I think after some back and forth, there was a consensus. Yeah, we were fine with that.
Right.
If you take on more than one, right? I think you had to take on a couple to get there. I don't know, Linda, if you're able to pull up what it was.
Yes. What we came up with is 1 hour of CLE per 125 hours of supervision. So, and I think the idea was that if someone was going to satisfy all of their CLE through this, that they should have to put in a lot of hours. But I think that this is sort of doesn't provide as much of an incentive if it's only 1 hour of CLE for each 125 hours of supervision.
I think what it was is that meant you got all of the COE proportionally in a year you would need if you did 100% of the supervision for the 1,000 hours
Right.
to
Right.
keep you in the program.
No, you'd only get 8. Am I missing it? You'd get 8 hours for doing 1,000. If it's 125 hours per hour of MCLE credit, isn't that 1,000 divided by 125? It's only 8 hours.
Right.
I
So
thought
you
I
wouldn't
thought we were
you wouldn't get it for doing one person. I thought we wanted to create it. I keep
Yeah.
remembering 4, supervise 4, and then you get all your CLE.
Right. Right.
Are you saying that all the CLE that would be proportionally for a year, or you mean all, was it 24 or 23 units?
Yeah, for a cycle.
Cycle, okay.
I agree. I think that's really an incentive.
So do we want to have, if one lawyer takes care of all the experiential for one student, we would allow that to take care of all their CLE for a reporting cycle.
Yes.
So that would be roughly what, 124 into 1,000. So what, 40, every 40 hours, they get 1 unit, and they could double up with more students.
And would the state bar then waive the ethics and the elimination of bias as well? So they could, that would be covered within that?
I don't think so.
No.
Yeah. So they,
I don't think so either.
I don't think
Yeah.
so either.
So do we want to change that they would get an hour for every 40 hours of supervision?
Except that they're still going to need to do elimination of bias, substance.
Right.
in ethics, yeah.
Right. Does that look right?
So what does that end up being, the total that they could earn?
25
Okay.
credits.
Yeah. So if every 3 years you take on one paraprofessional to give them their experiential, you've taken care of your CLE.
Yeah.
Other than the mandatory. And the state bar offers the mandatory units free online at this point.
Yeah.
Mhm.
Continue to do that.
Yeah, I think that's good incentive for someone to want to take that on.
Okay.
Yeah.
I think so too. Shows the program is important to the
Yeah.
bar.
And if it is in a firm, say for example, one attorney is supervising one, another attorney is supervising another. So there will be separate attorney declarations and they'll get the credit for the person working under them.
Yeah, I could see in the big firms, they literally could have, like, they could break up the experiential between different attorneys. Like have the attorney that focus on custody issues will work on custody experiential hours. And it's a viable model, whether it's for a solo practitioner or for, you know, a 20 attorney family law firm.
Mhm.
Okay.
Okay.
And I think you guys are done
That's great. Thank you.
for now. So we're going to send this to each of the practice area subcommittees, so they can develop recommendations, you know, for their specific requirements, curricular requirements.
And
Does
can
this
you,
mean-
That'll
do we
come
think we're
later.
done with do we think we're done with licensing completely now?
I hesitate to say it, but yes.
And Lee-
Until you're going to get something back from the practice area
Right.
subcommittee. Sorry, Judge Harper.
No, it's okay. I was just wondering, because you were at that board meeting, do you think this will satisfy their concerns about trying to make it less obstacles? And
I think so. I think it's going to be really important that sort of staff shows how we can generate a test fairly
Yeah.
quickly so that it truly is a viable pathway.
and I think the other thing that would be helpful if we receive this from the practice areas is for their practice area, specifically a list of, you know, like outcomes that they would like each person to be able to perform, skill specifics, so we can know, you know, what kind of a test would be created for each practice area. And then we can return to the educational requirements from those practice areas of, are there any of these courses that we're not going to require for a particular practice area or endorsement? And we can deal with that at a future time when they're closer to having that information for us. But I also think that if they knew that those would also be the kinds of items that we would require an attorney to list in a declaration for the experiential, then they can kind of see where our head is at about that. We would like the practice area to have certain skill set developed, and that this is how we intend to test or have an attorney attest to them meeting those requirements.
Okay.
Can I ask Claudia a quick question?
Go ahead.
So as a consumer, when you see these requirements, are you going to feel confident in the paraprofessional that's met these requirements?
I think having the oversight of the state board is very important, because that's the ultimate authority, right? It's important that that oversight is established. I very much like that there are alternative ways of meeting the requirements. I think that's very helpful. Definitely having the lawyers that are sponsoring the 1,000 hours listed and easy to identify, I think is very important. And all of that is going to help build that confidence, and I think create some nice opportunities for collaboration and even professional growth, I suppose, even for the consumer. They can become their own advocates with this structure, I think.
Thank you.
You're welcome.
All right.
Okay, and I
So-
will work on writing a draft of this subcommittee's recommendation to go to the full board for the February meeting.
So
And I
does
think
that
we should,
mean we're not having a meeting next week?
Not for licensing, right?
No, I don't know if when it's scheduled, but I don't think we need one if it is scheduled.
We do have one on the 10th scheduled.
Okay, well, I can send out a cancellation for that. Okay? Great.
Yeah.
Thank you.
All right, thank you.
I think we
Yeah,
should,
we all
we
have
should
to do
wrap
this.
up
Bye.
10 minutes. Let's wrap up 10 minutes early so Leah can stay in her state of shock and awe.
Thanks.
All
Can
right.
I-
Have a good
Can
weekend,
I
guys.
ask Linda
Bye.
a question when you all leave, please, when we stop the meeting?
Thank you.
Yes,
Bye,
let me
everyone.
stop. Okay, thank you.
Okay, so I don't recall